5 seconds to go. Start. When the appellant was not able to obtain reinsurance in the reinsurance market for getting it protected as per the requirements of business retention norms by the insurance industry, it has addressed a letter dated 11th November 2002 to the respondent for modifying the terms and conditions of the policy to reduce the insurance coverage to rupees 5 crores from rupees 10 crores. It is specifically mentioned in the letter dated 11th November 2002 issued by the appellant that the sum insured had to be kept at rupees 5 crores as no reinsurer was willing to accept the sum insured beyond rupees 5 crores. When the said proposal for revising the policy with a sum insured of rupees 5 crores was not accepted by the respondent, the appellant wide proceedings dated 25th November 2002 cancelled the policy by refunding the premium on pro rata basis for the remaining period, that is from 27th November 2002 to 6 July 2003. The respondent wide letter dated 26 November 2002 informed the appellant that there has been a shortfall of 283 kilowatt of electricity generated from 7th February 2002 to 20th November 2002 and the loss suffered was rupees 5 crore 20 lakh 37,800, and after deduction of 10%, the respondent has claimed an amount of rupees 4 crore 68 lakh 33,840. By the said letter, the respondent has made a formal claim with the appellant for reimbursement of the amount as per the terms of the policy. As the same was not acceded to, the respondent approached the National Consumer Disputes Redressal Commission, New Delhi, claiming an amount of rupees as per the special contingency policy. The appellant has filed written statement opposing the claim. While contesting the claim on various grounds, mainly it was the case of the appellant that the respondent has fraudulently suppressed the hydrological data of that project of the previous year. The plea of the appellant was not accepted by the National Commission, mainly on the ground that the appellant with open eyes had entered into a memorandum of understanding with the respondent and issued the policy on the same lines as that of preceding year for the year 2001-2 by duly incorporating the available hydrology data. The National Commission has found that there is no non-disclosure of material information in terms of the insurance policy issued by the appellant when the available hydrology data was duly supplied by the respondent and incorporated in the policy itself. Further, with reference to cancellation of the insurance policy, the National Commission has found that at no point of time there was any complaint of any material suppression with regard to hydrology data, and further noticed that the notice dated 20th November 2002 for cancellation of the special contingency policy was also only for the reason that the respondent was not accepting for amendment of the policy for revision of the sum insured to rupees 5 crores from rupees 10 crores only on the ground that they were not able to reinsure their interest. The National Commission, by clearly recording a finding that there was no suppression and fraud on the part of respondent, has allowed the claim of the respondent and directed to pay an amount of rupees which is the loss suffered by the respondent in terms of the policy along with interest at the rate of 6% per annum. We have heard Shri Mahavir Singh, learned senior counsel, appearing for the appellant, and Shri Neeraj Malhotra, learned senior counsel, appearing for the respondent. Even in this appeal, by referring to the impugned order and other material placed on record, the learned senior counsel appearing for the appellant has mainly contended that the respondent had obtained policy by playing fraud and suppression. As such, the respondent is not entitled to make any claim against the appellant. It is submitted that there is non-disclosure of previous hydrology data of the year 2001-2 before obtaining the policy, despite the same was available with the respondent. It is further submitted that after obtaining the subject policy from the appellant, few days thereafter, the respondent made a claim against the earlier insurer Messrs. IFCO Tokyo, which itself shows the wrong claims. Stop.